Hello, this is our third narrated PowerPoint on Study Unit 1, Introduction to the Law of Things and Property. In this narration, we will have a quick look at the property law sources and introduce the question as to how one should go about choosing between different sources of law where a right in the Bill of Rights has been infringed. So the sources of property law tells us where we find the legal norms that regulates, that makes up the law of things and the law of property. Now, broadly speaking, the sources of property law consist of the common law, legislation, customary law, case law, and the Constitution. Now, when we look at the first source is the common law. Now, the South African common law is also known as the Roman Dutch law, that predominantly consists of Roman legal norms with some Germanic customary law influence. It is, however, also prudent to acknowledge that a small number of English law norms of property law also forms part of the South African common law. Now, the common law can be found in the writings of the institutional writers. And just to name a few, the institutional writers include Foote, van der Linde, and Grotius. Importantly, the common law forms the backbone of the law of things. This means the common law is the source of property law where we find the legal norms that regulates the day-to-day aspects of how one can deal with your property, how one can protect one's rights over property, how one can dispose of property, and also when your rights in property comes to an end. So the place where we find these legal norms, the day-to-day legal norms of property law, is definitely the common law. The second source of property law is legislation. Now, with legislation, the Parliament is the author of this source of property law. Legislation is the source of property law that supplements and in certain instances replaces parts of the common law. Supplementation is evident where legislation regulates issues not covered by the common law principles of the law of things, whereas replacement is evident when Parliament promulgates a piece of legislation that is express about the fact that it replaces a certain rule or principle in common law. As the second, or rather the third source of property law that we can mention here is case law. Now, case law is the source of law or property law in which you will find interpretations of the legal norms that makes up the law of things. Case law is also where we find developments of the common law of things. In other words, courts are ordinarily called to provide interpretations of rights and entitlements over property. And many times we see that the court's interpretations then becomes authority for the ambit of a certain entitlement or a right in property. Also, we find that courts are also called upon to develop the common law in certain instances where a rule or principle in common law might not be equitable or might not have equitable results. So in order to then provide a remedy to the litigant in front of the court may be called upon to develop principles of common law. So in those two senses, case law or precedent is then the place where we find interpretations of rules and principles of the common law and also developments of the common law. A fourth source of property law is customary law. Now, customary law constitutes the source of property law which regulates customary and indigenous proprietary relations. These legal norms operate alongside the common law of things. And finally, we have the Constitution as another source of property law. First, the Constitution is a source of property law in that it contains Section 25, the Property Clause, which recognizes and regulates constitutional property. But it is also a founding and direction-giving document for all sources of law. The Constitution is the source of property law all the other sources must align with. In other words, all sources of property law must be viewed in light of the Constitution. So, just to reiterate, the Constitution really has a dual function. It is a source of property law in itself, but it is also the founding and guiding source for all other sources of property law. Now, as we've seen in the previous slide, there's a number of property law sources. We have the Constitution, legislation, common law, customary law, and case law. But the question that we will be exploring going further now, especially in the next narration, is how one goes about choosing between various sources of property law in the situation where there has been an infringement of a right in the Bill of Rights, and there are various possible sources available that could potentially be relied on to vindicate, to protect this alleged infringed right in the Bill of Rights. And the related question then that flows from that one is really whether or not it is necessary to have certain guidelines to help make this decision, and what is then wrong with just allowing a litigant to choose which source of law he or she wants to rely on based on what would work best for him or her. So the issue with allowing a litigant to choose which source of law works best for her or him is found in the fact that if a litigant is allowed to just choose, parallel systems of property law will be allowed to continue to exist independent from each other, and perhaps then also independent from the Constitution. So in more detail, or just to elaborate a bit more on that, is depending on the source that the litigant will rely on, there will be specific or unique requirements rather that needs to be met in the first place. Also, the specific source that the litigant will decide to rely on will have a very specific outcome that might exclude the promotion of ideals that's outside of the specific source that might be found, for instance, in legislation or the Constitution, if the relied upon source was, for instance, the common law. And then related to that one, if a litigant may just choose sources, yes, there will be specific requirements, a specific outcome, but it also impacts the ideals that we strive as a constitutional democracy to promote. Because if the common law is allowed to develop in isolation from legislation, the common law, and the Constitution, or legislation or customary law is allowed to just continue existing and protecting its own ideals, irrespective of, for instance, the common law and the Constitution, what will happen is that there would be a situation where either the status quo is protected completely to the exclusion of transformative goals of reform and change and inclusion, and on the other hand, the situation will take place where these reform goals are promoted to the exclusion of a certain level of certainty and certain level of protection of existing property rights. And this is problematic, right? The idea that parallel systems of property law can develop is problematic because the Constitution requires that there is a single system of property law that operates in South Africa. And the single system of property law is one that will promote both stability and change. In other words, protection of the status quo and transformation. And we will look at how the single system of law principle promotes the single system of property law in the next narration.